my channel. Today we'll be discussing about Muslim law, the nature and source. So, going forward, what we're going to discuss here, we'll have an introduction session, then we'll discuss about the nature of Muslim law and who is a Muslim, then sources of Muslim law, and then we will have a short conclusion. Now, as for introduction, Muslim law is similar to Hindu law in a way that it is a comprehensive system of laws. So, what does a comprehensive system of laws mean? It means that the Muslim law did have all kinds of law, like the contractual law, the criminal law. Everything was involved inside the Muslim law. And what we adapt to the Muslim personal law is only that personal matters which deals with the succession or inheritance, marriage or divorce, guardianship, maintenance, gifts and wills, wakaf, preemption, adoption, and religious endowments. Only those laws relating to these fields were adapted to the personal laws from the whole law of the comprehensive system, which had the criminal law and contractual law, civil laws, etc. Now, regarding the nature of Muslim law. Now, Muslim law is the words of Allah heard by Prophet Muhammad, and these words or these teachings were passed on through to the followers and the following generations through the narrators or the companions of the Prophet. When the Prophet was alive, he taught the words of Allah. He brought the words of Allah to the followers, and after the uh, Prophet's death, it was the companions of the narrators who continued this. So it's divine in nature. And since it is the words of Allah, it's in divine in nature, it's unchangeable. It's not a flexible law. Now, the Muslim law have, as I discussed earlier, it had a different forms of legal rules, not just pertaining to the personal matters, but as for the how a society should be, how a person should behave in the society, the contractual obligations, the trade etiquettes, the criminal law, everything. It had everything. It was a comprehensive system. Now, the fundamental source is always the Quran. When we discuss about the sources of Muslim law, the Quran is the basic or the fundamental source. So, who is a Muslim? A Muslim is any person who believes, professes, or converts to Islam. Now, what does beliefs and profess convey here? So, any person who believes that there is only one God and that is Allah, and Prophet Muhammad as their prophet. So, the essence of Mohammedanism, that is Islam, which means peace, consists in the faith that there is only one God and that Muhammad is his prophet. A person becomes a Mohammedan usually by birth to parents professing Mohammedanism or Islam. A person belonging to another faith may become a convert to Mohammedanism. So, when we discuss about conversion, it can be a conversion by a female or a male. So, what happens to marriage when a male and a female converts? So, apostasy, when a conversion to Islam is done by a wife, here, when the wife, suppose it's a Hindu married woman, when a Hindu married woman becomes a convert to Islam, this does not put an end to the previous marriage. Under the Mohammedan law, we have women also has to comply to monogamy. There is no polygamy for women in Muslim law. Polygamy is permitted only for men in Muslim law. So the previous marriage does not come to an end and she cannot remarry again. If the convert marries again, she is punishable for bigamy. Now, what happens when a male converts to Islam? So, when a husband converts or a Muslim husband becomes a convert to another religion, the marriage is automatically put to an end. So the wife can, without applying to a court for dissolution of marriage, marry another husband. Earlier we said when a non-Hindu converts to non-Muslim, when a non-Muslim female converts into Islam, her previous marriage does not come to an end. However, when a Muslim husband converts to another religion, the wife can remarry a Muslim wife, where the wife is still a Muslim. She can remarry without dissolution of marriage because the mere conversion of the husband to another religion will dissolve their marriage. So when a Hindu female converts to Muslim, her previous marriage is not nullified and she cannot remarry. But when a Muslim husband converts to any other religion, his marriage comes to an end and his previous wife can remarry without moving to the court for a dissolution of marriage. This is an important point that is to be noted here. Now, regarding sources of Muslim law. So the sources, mainly we will discuss about the primary sources, but we also have the secondary sources. The primary sources will be the Quran, the Sunnah, that is the traditions, the Ijma, that will be the legal decisions, then the Qiyas, the analogical directions. Then we have Hura, then we have Wahir, the Urf or custom, the judicial decisions, the legislations, and finally justice, equity, and good conscience. Please note that the concept of justice, equity, and good conscience, which forms the basic of natural justice, is a part in every kind of law, not just the personal law, just the Muslim law or Hindu law, but every kind of law. This is a principle that is prominent in every kind of law. And here we have to discuss about what is Khura and Wahir. So Khura is an Arabic word which means the reading of what ought to be right. What should be right? Now, Wahir is the first revelation that was in 609 AD, 609 AD, and it continued for 23 years. Here, the message of God delivered by angel Gabriel was heard by the prophet and then passed on to the people. Now, another important thing that we should take care of in Muslim law while studying or preparing for exams is that the Arabic words or the terms used. So we should know the meaning of these words and what their relevance in law. Now, going further in detail about the sources, first we'll discuss about Quran. So Quran had 6,237 ayat arranged in 114 chapters. These are called Surat and the epic titles. Now, Surat al-Nisa, that is one of the chapters that was relating to women. And Surat al-Nur, this is a chapter that discusses about the rules relating to home life. Then Surat al-Talaq, this is a chapter that which has rules relating to divorce. Now, out of the 200 plus verses, only 80 discussed about the personal laws. As I said earlier, the Muslim law was a comprehensive system of laws and it had all kind of laws. So, out of the 200 plus verses we had, there were only 80 that was discussed about personal laws. Now, the next one is Sunnah, the traditions or ahadith. Now, Sunnat al-Qawl. Here it refers to the words spoken by the Prophet. Then we have Sunnat al-Fail. Here it includes conduct, and behavior of the Prophet. So, Islam or a Muslim should stick on to the words spoken by the Prophet. That will be the law. That is the will of the God. And the conduct and behavior of the Prophet also lays down the rules how a person should behave or what is expected of a person. Now, Sunnat al-Tahrir, that is silence of the Prophet, which was considered as implied consent. So we will understand this clearer when we discuss later where there are pre-Islamic laws and post-Islamic laws. So even before Islam came into being, there were some practices and customs. So when Prophet came and he preached his teachings, he kept silent to some of the practices that was ongoing. And this silence was taken as implied consent, and those practices were considered as part of the Muslim law too. Now, Muwatta. This is a systematic collection of the narrations. Earlier I said about narrations that the companions of the Prophet, after the Prophet, the companions of the Prophet narrated the stories and the rules and regulations regarding his conduct, his lifestyle, and these became laws later. Now, Ijma. Ijma means the agreement of Muslim jurists. After the death of Prophet, those persons who had knowledge of law were called the Mujahids. You have to note here. Here it said Mujahids, where T is silent. They are also the jurist. So here we are discussing about the companions. So these people, the kinds of ijma, it's ijma of companion, ijma of jurors, ijma of people or masses. These are the narrators too. So those people who were along with the Prophet, who had an experience to be with the Prophet, they are the companions of the Prophet, and the ijma from these companions will have the highest value or authority. The prominent authority will be ijma of the companions. And then came the successors of the companions or the jurist. So these are people who are successors of the companions, and the companions who have a highest authority. It is a presumption that they have passed on all their knowledge to their successors, and thus they will be the most uh, appropriate jurors to make a decision. Thus, these jurors are also known as successors of companions, and Ijma of companion jurist had the second priority. Now came the successors of successors. That is the people who practiced the laws of Islam from as heard from the Prophet, the companions, the Ijma of the jurist. They pass down their knowledge to the next generation, the successors of the successors. That is ijma of the people or masses. That was there were the practices and rules that was followed by a huge mass of people who follow Islam. So these three kinds of ijmas, they are also known as the narrators or the kinds of narrations. That is the narrations by the companions, narrations by the successors of the companions, and narration by the successors of companions. So these three are interchangeable, the narrators and the kinds of ijma. The kinds of ijma will be ijma of companion. Who is a companion? Those are people who are along with Prophet, who has witnessed the lifestyle and the conduct of the Prophet in first hand, in direct contact. Now, ijma of jurists. These jurists were mostly the successors of the companions. It was a presumption that the knowledge of the companions were completely passed down to their successors, and thus they will have the second most prominent place in making a decision. And then those people who have been following Islamic rules for a long while, the successors of successors, that is ijma of people or mass. Now we have qiyas or analogical deductions. So qiyas came from a word called yakish, which means be together. The Arabic word qiyas means measurement, accord, or equality. So what we do here is like we are measuring a subject matter to a standard. And what is this standard? This standard is what has been discussed in Quran or by the Ijma or what has been being practiced in Islamic laws. So this measurement or accord or equality with the standard is what we are considered here. So this is something that we compare and deduce. So that is analogical directions. So this was done to extend the law of text to cases which do not fall within the purview of the text. So if there, for example, if there was a example set by the Muslim law about the conduct of a person in a particular situation, and there is a new situation where we do not know how to set a standard of conduct, then we will compare what was intended by what was set forth by the prophet or the previous law about the conduct of a person in a social gathering, and this will be compared with the current subject matter we have at hand. Then a analogical deduction is produced on the standard or what should be the conduct of a person in the present current matter. So there are some conditions for valid qiyas. One, it will be applied only to those texts which are capable of being extended. So if the text is something of a closed subject, you cannot use that for something about a strict no or rules. We cannot extend that to other cases, such as the religious practices, the rituals performed by the Muslim people. Those are strict rules and we cannot extend those to other fields. Now, analogy deduced should not be inconsistent with the dictates of the Quran or the authority of the Sunnah. So we discussed about Quran. It is a highest, it is a fundamental source of Muslim law and the highest authority. Then we have Sunnah, the traditions that has been followed. So whatever analogy we have deduced, that should not be inconsistent with what the Quran states or what the authority of the Sunnah has put forth. Now, the third one will be applied only to discover a point of law and not to determine the meaning of the text or verse used. So, we cannot use this method or the analogical deduction to bring about a new interpretation, but this is used only to bring a new subject matter into the existing law. Now, it must not bring a change in the law embodied. So, it is to bring a subject matter to the existing law, not to change what is already existing. Now, we have urf or custom. Now, well, regarding urf or custom, we referred to this earlier. We have pre-Islamic period and post-Islamic period. Even before Islam came into being, there was a society and there were some practices going on. So the Prophet came and preached the words of Allah to his followers and other people. So there was some instances where the Prophet was silent on the existing customs, and the Prophet laid down new rules and conduct for the those set of customs where he was not silent. So where he was silent, the Prophet was silent. It was considered as implied consent that the Prophet is saying that these practices are right. It was considered as implied consent, or the Prophet saying it as those customs are right to be followed and it is to be continued to be followed. Now, what is a valid or legitimate custom? So, not all custom is valid or legitimate. So, what is a valid or legitimate custom? So, here we have it should be repeated regularly. That is continuous and noticeable. It's not something which happens once or twice. It has been continuing for a while and it is having a noticeable effect. Now, applicable to everyone and rational. It should not be irrational and to do what isolate or suppress one community or something. What is there? It should be normal to everyone. Must not contradict to any implied text of the Quran or Sunnah. So this is a fundamental principle when it comes to Muslim law. We have seen this in conditions for valid qiyas too, that whatever we deduce or whatever we follow should not contradict to Quran or the Sunnah. Now, does not have to be ancient. So a practice need not be very ancient, so it has been practiced for like time immemorial, but it had to be continuous and noticeable for a while. So that is with valid or legitimate custom. Now we have judicial decisions. So judicial decisions are based on the principle of stare decisis. So what is stare decisis? What does the doctrine say is like what has been decided. Let it stay as such and not to disturb those decisions. So if there was a case of a similar case of similar facts and subject matter, and then we use the same decision of that case in a later case, that provided the subject matter is same and the facts are similar, then we can use a previous decision as a reference or the same decision in a later case. So here we discuss about fatwas. Those fatwas had the moral and legal authority, and these fatwas are the most closest that was applied, like where we implement the principle of statuses in Muslim law. This was the closest that we see to it, fatwas. Now there were Qazi judgments, but the Qazi judgments were not regarded as a precedent. And when a mufti declares a fatwa on a scholar, the Qazi was not obliged by it. Now, the most noted and most discussed fatwa is Fatwa al-Alamgiriya. Now, the final source is the legislation. Uh, this is a final source, and then we have one more principle regarding sources, that is justice, equity, and good conscience. So, as a source, it's legislation. So, according to Cambridge University, what is legislation? So, it is a law or set of laws suggested by a government and made official by a parliament. So, Muslim law here, they accepted some of the legislation as part of their personal law, and it is called Nizam, that refers to the ordinance or decree. Now, some of the examples of these legislations are like Muslim Waqf Validating Act that was brought in 1913, the Shariat Act that was brought in 1937, then the Dissolution of Muslim Marriage Act that was brought in 1939. Yet the personal law is still expanding. We can see right now we have many case laws such as the Triple Talaq case, then where the Shabana Banu case, and then the court held that the 125 of CRPC maintenance shall be applied. Like it is open for the Muslim women to apply for it. So even the personal law has been evolving. So it is, we can expect more legislations in this regard. Now, the principles of justice, equity, and good conscience. These are the basics that forms the principles of natural justice. This is something that has been applied in every kind of law. And why? Because the law, the basic intention of having rules and laws is justice and equity. Now, we are making laws for the good of the people and out of good faith. No one wants to follow a law that is made of malfaith. So, these are the basic principles of natural justice. Now, when we summarize Muslim law, the Muslim law and Hindu law is very similar in the case that they have a comprehensive system of laws, but yet are whole different because even Hindu law has two kind of schools, Mitakshara and Devbhaga, which are now codified into one. But here in Muslim law, we still have the difference in laws of Sunni and Shia, the two main schools, and Muslim law has many different kind of types of marriage, whereas Hindu marriage doesn't have different kinds of marriage as of now. So, though the person it is very similar to other personal laws, yet it is a whole different. Muslim law is not completely codified even now, and there are various sects of schools of Muslim law, each of whose personal law is different. This can be mainly seen regarding the marriage, dower, succession, etc. among Muslims. The difference between Sunni school and Shia school is a very important topic to be understood, and it's a very important question for our exams too, especially with respects to their consideration of what is a valid marriage and how a succession should be. So this will be dealt in detail in a later video. So thank you. Please like, share, subscribe, and comment to our videos. Let us know your feedback and the topic on which you would like to see a video or presentation on. If there is anything that I have missed to add in this video, or there is anything that you would like to add as an important point regarding this subject, please drop that in the comment box below so that whoever sees this video can go to the comment box and update their notes or their knowledge. And thank you. See you again in the next video. Thank you once again.